Assalamualaikum and hi, my name is Mariaminti Supradi, matrix number BB23110329. In this video, I will explain a case involving oceanic lines and a fire caused by wrongly declared cargo. This issue here is whether Oceanic Lines is responsible for the loss when a container declared as metal parts actually contain flammable materials which cause a fire and destroyed the cargo. In this case, we use Hutch-Visby rules. A carrier must take a reasonable step to make sure the ship is seaworthy before the journey starts. This means the ship must be safe and suitable to carry the cargo. However, if dangerous goods are shipped without the carrier knowing or agreeing to it, the responsibility for any loss falls to the shipper. This rule was confirmed in the case of the Genis NK in 1998. In that case, the court decided that the shipper is responsible for those caused by wrongly declaring dangerous goods even if the carrier did not know the cargo was dangerous. In this case, the fire happened because the cargo was dangerous and was wrongly declared as a metal parts. Oceanic Lines did not know what was really inside the container. This is also no evidence that Oceanic Lines failed to take proper care to make sure the ship was safe at the start of the journey. The fire was not caused by the crew or by any problem with the ship. It happened because the dangerous cargo was hidden due to the wrong declaration. Therefore, Oceanic Lines is not responsible for the loss. The responsibility stays with the shipper according to the Hutch-Visby rules and the decision in the Genis NK case.
My name is Rachel. So next is issue 2. Today I will talk about misdelivery and conversion by Oceanic Lines. The issue is that cargo was delivered without the original bill of lading, even though it was shipped under a negotiable deal. Why it matters? A bill of lading is not just a receipt or proof of contract. It is a document of title. The carrier has a strict duty to deliver only when the original bill is presented. Under Article 3, Rule 2 of Hutch-Visby rules, adopted in COXA 1950, delivery without the bill counts as conversion. The carrier is strictly liable and cannot escape responsibility through contractual clauses or employee errors. The case suffered this is Zahatang 1959. Good faith or honest mistake don't excuse conversion. Motors Export 2000 misdelivery is not protected by Hutch-Visby expectation. Captain Gregos 1990. Port staff negligence does not remove carrier liability. In this case, cargo was delivered to a neighboring mill by mistake. This is clearly misdelivery and conversion. The carrier's strict duty means the porter's error is not an excuse. For the conversion, Oceanic Lines are liable and Tropicana can refuse payment and claim damage.
My name is Nursyahadaying binti Marmuki, Nometric BB23110407. Today, I will present Question 2, Issue 1, which involves a CIF contract. The main issue in this scenario is whether Orchard Export, as the seller, entitled to claim payment from Baymil, the buyer, under a CIF Port Klang contract, even though The goods were lost at the sea before arriving at the destination port. Beimu refused to pay because the rice did not arrive. To answer this, we need to consider the rules of CIF contract. A CIF contract is an international sales contract where the price agreed upon includes the cost of goods, shipping, and insurance. It is important to note that a CIF contract does not guarantee that the goods will arrive at the destination port. Instead, it is a document-based contract. This means that the seller fulfills their obligation by shipping the goods and providing the buyer with valid shipping documents. This document includes the invoice, the bill of lading, and the insurance policy. The presentation of this document is considered a symbolic delivery of the goods. Courts have confirmed this principle or rules in several cases. For example, in Aarholt Carpet Builder in 1915, it was held that the seller's duty is to deliver the goods and obtain carriage and insurance, not to guarantee their arrival. Similarly, in Johnson v. Taylor Bros. In 1920, the court clarified that the seller fulfilled their obligation when the contract documents are presented. Furthermore, the risk of loss passed to the buyer once the goods are loaded on board the ship. Regardless of when ownership passed, the principle is also supported in E. Clements Horst v. Biddle Bros. 1911 and the Julia 1949. The insurance required indicate that the parties intend the risk to pass at shipment, not at arrival. The buyer must accept valid document and make payment without waiting for the goods to arrive. In this scenario, for application, Orchard Export shipped the rice according to the CIF Port Klang contract. Unfortunately, the vessel sank during the voyage, resulting in a total loss of goods. However, since the loss occurred after the goods were shipped, the risk had already passed to Beimu at that time. 2 days after the incident, Orchard Export presented a complete set of valid documents including the bill of lading, commercial invoice, and insurance policy according to the principle of CIF contract and as confirmed in Ross T. Smith v. T.D. Bailey 1940. The seller had fulfilled their contractual obligation by providing this document. Beimu's refusal to pay because the rice no longer exists is therefore contrary to the nature of the CIF contract. The purpose of the insurance arranged by the seller is to protect the buyer against the risk of loss during transit. As emphasized in the Julia case, the loss of the goods after delivery does not affect the seller's right to receive payment once valid documents have been presented. So, in conclusion, Orchard Export is legally entitled to demand payment from Beimu under the CIF contract. Beimu is not entitled to refuse payment because the risk has passed to the buyer once the goods have been delivered and the seller have produced document in accordance with the contract. Beimu remedy is to make a claim under the insurance policy provided.
Hello, today I am analyzing the FOB dispute between Orchard Exports and Global Foods using the IREC method. Starting with the issue and the rules, the primary legal issue we must address is whether the June 1st deadline for vessel nomination was a condition or a warranty. This classification is critical because if the deadline is a condition, the seller has the legal right to terminate the contract immediately upon a breach. To determine this, we look at two main legal frameworks. First, in COTEMS 2020, Article B2 established the buyer's mandatory duty to nominate a vessel and provide a notice of readiness. Second one is the Sale of Goods Act 1979, Section 10, Subsection 2, alongside the landmark House of Lords ruling in Bunch Corp v. Tradex 1981, confirms that in international mercantile contract, time stipulation regarding shipment and nomination are one of the essence, this means that the deadline is strictly classified as a condition under English law. Next, for the application and conclusion, when we apply these rules to the fact, we see that Global Foods nominated the ship on June 15, which was 14 days after the agreed deadline. In the context of international trade, this is a significant delay. According to the principle of commercial certainty, exporters like Orchid Exports rely on strict deadline to coordinate port logistics, manage loading schedule, and avoid expensive warehouse storage fees. Because the deadline is a condition, this 14 days delay constitutes a repudiatory breach under Section 11, subsection 3 of the Sale of Goods Act 1979. Orchid Exports was not required to accept late performance and had the absolute right to treat the contract as terminated. In conclusion, Orchid Export acted perfectly within their legal rights and the contract was lawfully terminated. Global Foods' claim for wrongful termination is invalid and the buyer remains liable for the breach of contract. Thank you.